Welcome to California Bar Prep, your study companion for the California Bar exam. In this lesson, Torts Overview, Fault, Injury, and Civil Responsibility. Let's begin. Torts asks when one person must pay for harm to another. The exam organizes liability around different theories: intentional interference, unreasonable risk, strict responsibility for dangerous activities or products, and injury to reputation, privacy, land, or economic interests. The plaintiff must prove duty or protected interest, breach or wrongful act, causation, and damages unless the tort is actionable, without actual damages. The MBE applies majority rules. California tort law often follows modern comparative fault and strong public policy duties, but essays usually reward mainstream doctrine unless California distinctions are cued. Always identify the theory before discussing defenses. Consent defeats many intentional torts. Comparative negligence reduces negligence recovery. Assumption of risk may limit or bar claims depending on context. Privileges protect speech and property defense. Intent. For intentional torts, intent means purpose to cause the contact, confinement, apprehension, entry, or consequence, or knowledge with substantial certainty that it will occur. Transferred intent applies among battery, assault, false imprisonment, trespass to land, and trespass to chattels when the defendant intends one of those torts against one person but causes another. Negligence. Plaintiff must prove duty, breach, actual cause, proximate cause, and damages. Duty is owed to foreseeable plaintiffs. Breach is failure to act as a reasonably prudent person under the circumstances. Actual cause is usually but for causation. Proximate cause limits liability to foreseeable results, subject to special rules for intervening forces. Strict liability. A defendant may be liable without fault for abnormally dangerous activities, wild animals, and defective products. Plaintiff still must prove causation and damages. Intentional torts. Battery. Intentional harmful or offensive contact with plaintiff's person. Contact with something closely connected to the person counts. Plaintiff need not be aware at the time. Assault. Intentional creation of reasonable apprehension of imminent harmful or offensive contact. Words alone are usually insufficient unless coupled with conduct. Plaintiff must be aware. False imprisonment. Intentional confinement within bounded area, plaintiff aware or harmed, with no reasonable means of escape known to plaintiff. Intentional infliction of emotional distress. Extreme and outrageous conduct, intent or recklessness, causation, and severe emotional distress. Common carriers and innkeepers may be liable for gross insults under traditional rules. Trespass to land. Intentional physical invasion of land. Mistake is no defense. No actual damage is required. Trespass to chattels and conversion. Interference with personal property. Conversion is serious interference requiring payment of full value. Trespass to chattels requires dispossession, impairment, or damage. Negligence framework. Duty. General duty of reasonable care to foreseeable plaintiffs. Special duties arise for professionals, land possessors, rescuers who undertake aid, common carriers, innkeepers, employers, and those who create risk. Breach. Compare conduct to reasonable person. Custom is evidence, but not conclusive. Statutes may establish duty and breach through negligence per se. Causation. Actual cause links breach to injury. Proximate cause asks whether the injury is within the scope of risk. Damages. Negligence requires actual harm. Nominal damages are not enough. Comparative fault. California follows pure comparative negligence. A plaintiff's negligence reduces recovery by percentage of fault, but does not bar recovery, even if plaintiff is mostly at fault. Primary assumption of risk. California uses primary assumption of risk especially in sports and recreational activities. If the defendant owes no duty to eliminate inherent risks of the activity, plaintiff may be barred. Defendant still owes a duty not to increase risks beyond those inherent in the sport. Duty analysis. California courts often begin with a broad duty of ordinary care and then analyze policy factors to limit duty. In bar answers, mention foreseeability and policy if a novel duty issue appears. Premises liability. California generally applies ordinary negligence principles to land possessors rather than rigid common law entrant categories, though entrant status may inform foreseeability and reasonableness. The MBE still tests invitee, licensee, and trespasser categories. Intentional tort intent is not intent to harm. Intent to make offensive contact is enough for battery. Assault requires imminence. A threat of future harm is not assault. False imprisonment requires bounded confinement. Blocking one route when another reasonable route is available is not enough. Negligence per se may establish duty and breach, but plaintiff still proves causation and damages, and the statute must protect this class from this type of harm. Rescuers are foreseeable. A negligent defendant is liable for injuries to rescuers unless the rescue is reckless or extraordinary. Eggshell plaintiff rule applies after a tort is established. Defendant takes plaintiff as found for extent of damages. MBE torts questions often turn on the first element. If there is no duty, no protected interest, no actual damages, or no intent, later analysis is irrelevant. Read the call carefully. Is it asking strongest claim, best defense, liability, or damages? For essays, use headings by claim. For each defendant, write the tort, elements, defenses, and damages. If multiple plaintiffs exist, analyze each separately. Transferred intent, bystander emotional distress, and comparative fault are frequent point sources. Note: torts is fact-intensive, but the rules are stable. Do not write a moral essay. Identify the protected interest, the wrongful conduct, causation, defenses, and remedy. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.